Equipment Agreement, Railway Car Tank Requirement Lease Agreement TRLI 2001B Exhibit. Section 5, Disclaimer and Warranties. Section 5, Disclaimer of Warranties. Without waiving any of the claim of the lessor, may they have it against the seller, the supplier, the manufacturer. The lessor acknowledges that in agreements that each of the unit is of size, design, capacity, manufacturer selected, and any acceptable to the lessor. The lessor is satisfied that each unit is suitable for the purpose of the lessor and has accepted each unit. Neither the lessor nor owner participation of the manufacturer or dealer in any property of such a kind has inspected the units prior to delivery to and accepting the lease. Acceptance by the lessor. In each unit, the lease herein subject to all applicable laws and governmental regulations now in effect hereinafter adopted by the leaser, and the lease is and the lessor takes each of the unit as is, where it is, and with all faults in whatever condition it may be. The lessor acknowledges that neither the leaser as the leaser or individual capacity nor own participation makes nor shall be deemed to have made each expressly disclaims in all rights and claims warranties representatives either expresses implied or as is the value, condition, and fitness for any other particular purpose, design, operation, merchantability, therefore, or as to the title of any unit, the quality of the material, workmanship, thereof, in conformity thereof, the specification, freedom of patent, copyright, trademark, infringement, the absence of any of the latent other defect, whether the non-discoverable or other absence of any obligation based on strictly liability and tort, and any other express implied representation of the warranty whatsoever, the respect thereto, and each of the leaser and owner or participation expressly disclaims the selection of the units, except for the leaser in individual capacity represents the warranties. Of the closing date, the leaser shall have received whatever title of each of the unit was conveyed by the leaser by the lessor. Each of the unit will be free of the leaser's liens attributed to the lessor. The leaser shall have received whatever title of each of the unit conveyed by the leaser to the lessor of each of the unit will be free of the leaser's liens attributed to the leasers, and provided by the foregoing of the disclaimer clause that shall not be extended to the owner participation representation warranty contained in section 3.5 of the participation agreement. The leaser hereby appoints to constitute the lessor and its agent and attorney in the fact during the lease of a term, and is asserted in force from time to time in the name for the account of the leaser and to the lessor is in the interest may appear, but in all cases the sole cost expense to the lessor, whether the claims rights of the leaser may have as ownership against the manufacturer any prior owner thereof, provided here over there any in time of the lease event of the default shall have occurred, and continuing the leaser's option such as the power of attorney shall terminate and leaser may assert and enforce at the lessor's sole cost expenses such claim as the rights the lesser delivery as the lease supplemental shall be conclusive evidence between the lessor and the leaser that the units are described therein in all foregoing respects of the satisfactory to the lease or to the lessor, and the lessor will not assert any claim of any natural whatsoever against the leaser based on any of the foregoing matters. Section 5.2 rights and under existing equipment subleases unless the lease event of the default shall have occurred and be continuing under Section 14, the leaser shall have been given a written notice between the lessor and the leaser agrees to make available for the to the lessor such a right of the leaser may have. The lessor shall have entitled to the exercise all rights of the leaser under each sublease. Return of equipment and storage.